Can an employer fire an employee just based on that employee's status as either homosexual or transgendered? To find out, you have to read the landmark case of Bostock versus Clayton County, Georgia. But it's 72 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read. Normally, I cover Court of Appeals cases in 5 minutes or less, but this is part of a series, a special series I'm doing on cases related to LGBTQ plus issues, landmark cases, and this is the episode that's perhaps the most recent, impactful case out of that area, and it's Bostock versus Clayton County, Georgia. This is a recent case. It's from June 15th of 2020. The majority is written by Judge Gorsuch of the Supreme Court. And the issue in this case is, does Title VII of the Civil Rights Act of 1964 prohibit discrimination on the basis of sexual orientation and transgender status? I'm going to explain the law that you have to understand to appreciate what's going on in this case and where the judges are coming from. In 1964, President Johnson signed the Civil Rights Act of 1964 that had a variety of different areas. They were called titles, Title I, Title II, Title III, Title IV. Title VII related to employment discrimination. And under Title VII, an employer is not allowed to take adverse employment action, firing, discharging, otherwise discriminating against an employee on 5 specified bases. Those bases are race, color, religion, sex, or national origin. If an employer takes an adverse employment action on one of those prohibited bases, they're liable for violating the Federal Civil Rights Act of 1964 and can be sued. So what's going on in this case? What are the facts? The facts are not complicated here. This is 3 companion cases. Basically, these cases are the named one is Bostock versus Clayton County, Georgia. That's where there's a gay man who works for the Georgia Department of Social Services. There's another case where there's a gay individual who works for a skydiving organization. And the third one is a transgendered person who works for a funeral home. And basically, in each of these circumstances, each of these cases, their transgender status and or sexual orientation is discovered by the employer. Shortly afterwards, the employer fires each of these 3 individuals. And it's not really a question here about whether they did that on the basis or whether they did it because they were gay or transgendered. That's sort of that's not disputed. The question is, are they allowed to take an adverse employment action on the basis of sexual orientation or transgender status? And on that, the majority comes down and says, and analyzes this, tries to do a textual analysis, and in fact cites to Scalia and the textual school of thought of the Supreme Court and says, the question here is, what is the ordinary meaning behind because of sex? Because that's the prohibited thing here. And they say that sex means male or female, and because of means as a result of or partly, even if it's 1% based upon sex, then it's because of sex. And they say that it's undisputed. They say it's a simple application of the statute of the text. And they say here it's simple application to find that discrimination on the basis of sexual orientation and transgender status is because of sex. Why is that? They use it by hypothetical. They say, or here's an example. They say it's impossible to discriminate against someone for being homosexual without it being based on sex, because if you're firing a gay man for being attracted to men, but you don't fire women for being attracted to men, then you're firing him because he's a man, not a woman. And his attraction is to a man. So that's because of sex. With respect to transgender, if you fire a person who was assigned male at birth, but identifies as a female, but you don't fire a person who was assigned female at birth, who identifies as female, then you're punishing that person for their sex. It's as simple as that, according to the majority. And the rest of the long decision is essentially refuting counter arguments and showing how their finding is consistent with the precedent. Okay, but there's 2 dissents in this case. That's the majority. The 2 dissents are by Judge Alito and Thomas is one dissent, and Kavanaugh is another one. And basically, they refute the whole thing and say sex is different than sexual orientation and transgender status. That it's always been considered so. That it violates the spirit of what happened in 1964. And they say that this is not what was meant or what was meant by the legislators who passed it, or what ordinary usage is of the term sex. But that's the case of Bostock versus Clayton County, Georgia. And what it means is that employers are not allowed, based upon this decision, which included Judge Ginsburg, who's no longer part of that court, and did not include Judge Comey Barrett, who is now part of the court. Employers are not allowed to discriminate on the basis of sexual orientation or transgender status. Too long didn't read, 5 minutes or less. Have a good day. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.